tonight, and this probably is about a 3-hour training that we're going to get down to 29 minutes. So I want to walk you through the packet that's in front of you first, and then we're going to concentrate on a few specific things. The board's packet includes a letter, I think at the start, dated March 7, 2018, and it deals with recent land preemptions, non-conforming structures, and lot issues. That's not actually a major issue tonight. This is being provided to you for informational purposes, and you can read it at your pleasure. There was a U.S. Supreme Court case that came down that the legislature was not happy about from Chippewa County, and they passed several laws to deal with that and several other, constantly working with non-conforming structures. The key thing about non-conforming structures is it has to have a legal use. So if you're talking about a duplex, this doesn't apply. If you're talking about a property that has a guest cottage on it, this doesn't apply. The only time we all constantly have to remind people, all of these laws about legal non-conforming structures only deal with structures that have conforming uses and the property is conforming. And it basically is talking about properties that are too close to the lot line and what your rights are to rebuild them. When those issues come up, we will deal with that letter in greater detail. It's just provided to you for informational purposes. The next document you have in your packet, we're going to come back to in great detail, and that is the new law on conditional uses, which in our opinion dramatically changed the law on conditional uses. I'm going to hand out to you a letter which summarizes the new law in great detail. And again, we don't have time to go through it. I'm going to highlight a few things as I go through the new law from this letter that are important for you to keep in mind as you go forward and you deal with conditional uses. But this is our opinion letter that was issued back in December. Some of you may have already seen it. Hopefully many of you have already seen it, but it deals with, it details what I'm going to be talking about a little bit later. So you may want to set it off to the side. Next in your packet, you have some samples that Kathy's provided to you of our current language dealing with conditional uses. First is 3-2-9 conditional uses, deals what our approval is required, what our applications are, public hearings, and things like that. That ordinance is in place, and we'll be following that ordinance as long as it's consistent with the new law. And then she also provided for you two samples of conditional uses that are on the books that show what certain of the requirements are and conditions that are in the ordinance. And why that's important, again, will become apparent as we go through the document. I think that then you should have a document with yellow printing on it. Is there anything else? I think I've highlighted what you have. This is what we're going to concentrate on, and I ran 130 of them so everybody in the audience can have one and follow along. This is exactly what was on the first document that you had, which said conditional uses in smaller print. It's the exact same thing, but I'm going to highlight certain things, and that's why it's been highlighted and yellow highlighting on it. So Act 67, called the Landowners Bill of Rights, made, in our opinion, dramatic changes to the conditional use law. If you talk to the senator and the representative for the law, they will tell you that they were deliberately trying to change conditional uses from a privilege to a right. So it used to be for many, many years, and the courts upheld that concept that they were uses that were to be allowed in specific instances, in appropriate instances with the appropriate conditions, but no one had an absolute right to a conditional use. The drafters of this law will tell you that they were trying to change that. And they were saying that if we go through this, you will find that if a petitioner meets the requirements of the code, the conditions in the code, And those that are imposed, and there are restrictions on what you can impose, the municipality must, it says shall, issue the conditional use. So let's go through this document. We're going to read the new law. I don't like to read laws, but in this case, you know, I got it on one page and I think we can get through it because the bottom parts on appeals and things like that don't apply. Conditional use means a use allowed under a conditional use permit, special exception, or other zoning permission issued by a city, but does not include a variance. Okay? We all know what a conditional use is. You should know, some of you will know that conditional uses before they were called conditional uses were called special exceptions in some of the old codes. And if you read the old case law, the word conditional use was not used. It was a special exception. And what the legislature was specifically doing, and again, I have talked to the drafters, they wanted to make sure that you didn't go through your code and change the word conditional use to special exception or special zoning permission and then say the new law didn't apply. So they were very deliberately saying that if you have conditional use is broader than just what you might call a conditional use, it also applies to special exceptions, zoning permission, and other things, but not variance. Now, we do have special exceptions in our code, but they don't generally deal with use. If there is a special exception in the code, ours usually deal with height for an accessory structure or a lesser side yard or setback or number of buildings. And we're going to now have to analyze those special exceptions to see if they fall under this new law or not. If they deal with the concept of use, yes, they will fall under the new law. But that's not the main part of the training tonight. The main part of the training is about those that are absolute conditional uses. We know they're conditional uses. There's no question that they're conditional uses, but you need to know the law applies to more than what we call conditional uses. That also applies to special exceptions or special zoning permission when they deal with use. Substantial evidence, by far, one of the most significant aspects of the new law. Substantial evidence, and they mention it 3 or 4 times in this new law. Substantial evidence means facts and information. It's very important because they specifically said other than merely personal preferences or speculation. So no longer will substantial evidence be merely opinion. The opinion needs to be substantiated by facts and information to justify that opinion. And that's unfortunate for both the petitioner and for, you know, the objectors or questioners, because many times they show up with just an opinion. And the legislature has specifically said, you no longer, as the decision maker, can take into consideration mere personal preference or speculation. It has to be substantiated. Now, substantial evidence, you're going to find out why that's so important, okay? And then it goes on to say that substantial evidence has to be substantially pertaining to the requirements and conditions an applicant must meet to obtain a conditional use permit. So what the legislature said in that section is if people are petitioner and or property residents are talking about all kinds of things that have nothing to do with the requirements or the conditions imposed by the code, you can't take that into consideration. So if they're telling you all kinds of stuff that doesn't have anything to do with the conditions in the code, that is not considered to be substantial evidence, and you can only deal with facts and information pertaining to the requirements and conditions that the applicant must meet to obtain a conditional use permit. And that substantial evidence has to be what reasonable persons would accept in support of a conclusion. So they've dramatically narrowed what, in our opinion, and most of the attorneys in the state's opinion, what petitioners and residents who show up at a public hearing talk about, and they have to pertain to the requirements and the conditions. Now, you know, because I've stated this before at meetings, that they adopted this law and they didn't give us any time to rewrite our code to put in requirements and conditions. And that's why Kathy gave you samples of what's required for some of the conditional uses, the in-law unit, the commercial kennel. We were going to have airport, you know. Those are what you have to look to. and there's a limited exception a little bit later on in the code, in the law, but that's where we start. And when we get to the planner's report for the conditional uses in the future, he's going to lay out, and actually when it comes time to deliberate, we're going to give you a list of the requirements and conditions in the code, if there are any. And then you're going to decide whether the petitioner presented substantial evidence as defined to support those requirements and conditions, or whether he didn't or she didn't, and whether the residents, if there are any residents opposed to the conditional use, presented any substantial evidence. We had a hearing last week. I've had a number of hearings under the new law recently, and we had about 30 or 40 people there. It's been in the paper probably. You probably heard about it, so I'm not telling any secrets. It's a public meeting. It was a third time special event. It's been turned a special event venue. It's been turned down twice before. Okay, we've got 30 to 40 people there. And they know this. They didn't know the law. They now know it. They did know it, but they did not bring in any substantial evidence. And they sort of admitted it. But it was adjourned for the next month because almost every hearing is going to be at least 2 months, if not 3 months of public hearings now, for reasons that we'll explain. And they were here to listen to what the petitioner had to present as his substantial evidence on that venue. And then they were going to counter it next month and present their substantial evidence, a counter to the petitioner's substantial evidence. And they admitted they gave a lot of opinion, that it's going to be too noisy or it's going to be too brighter, but they had no evidence. And they admitted they had no evidence. And they said, we'll be back with our evidence. Okay. So, I mean, that group is as I said, it's their third time around. They've been studying the new law, and I fully expect they're going to be back next month at the next public hearing to present substantial evidence, meaning facts or information other than mere personal preference or speculation, and they have to directly apply to the requirements or conditions in the in the code that the applicant has to meet. Okay, is everybody following that? That's really important. You got to understand that. Then it says if the applicant for the conditional use meets or agrees to meet all of the requirements and conditions specified in the city ordinance, or those that the city comes up with, the city, it's written for cities, but you all know it applies to towns and villages, the governing body shall grant the conditional use permit. It's no longer a privilege, it's a right if they meet the substantial evidence. And I've always found it interesting because Dodge County, and I found out at a national seminar that I was speaking on the day that they introduced this new bill, we had a land use seminar in Madison, and Dane County said they've always read it this way. Dodge County, I know because I represent a community in Dodge County. Dodge County has always taken the position that if you meet the factors of our ordinance, you get your CU. It doesn't matter if there's any objection or not. And they've always taken that position. The attorney from Dane County said, yeah, we've always interpreted that way. This isn't going to be a big change for us. In my opinion, this is a huge change for the communities in Waukesha County. Waukesha County has always religiously held that a conditional use was a privilege, not a right. And the mere fact that they met the requirements of the conditions, if they could find reasonable basis for denying the conditional use, they could deny it. But now it's very clear that if they meet the requirements and conditions specified in the code and those imposed by the Plan Commission and the town board, you shall grant the conditional use. And go back up and it shows the applicant, well, I guess we'll get to it. Any condition, then it goes on to say that any condition imposed, meaning one that's not a requirement or a condition in the code, you come up with a new condition, okay? Which it says you can. They have to be related to the purpose of the ordinance and be based on substantial evidence. So you can't just come up with conditions. They have to be related to purpose of the ordinance. So if it's not in the code as a requirement or as a condition, it's a condition that you're going to come up with to impose on the conditional use. It has to be related to the purpose of the ordinance. The requirements and conditions described in 2A, so those are the requirements and conditions in the code, or those that you're going to impose as part of the process, must be reasonable and to the extent practicable, measurable, and may include conditions such as the permit's duration, transfer, or renewal. So again, they're putting I believe the legislators are putting restrictions on the types of conditions you can write in your code, and those requirements and conditions you're going to put in your code, as well as those that you may try to impose as part of the conditional use process. And then it goes on to say, of course, the applicant must demonstrate that the application and all requirements and conditions established by the city relating by the conditional use are or shall be satisfied, both of which must be supported by substantial evidence. So the petitioner has to show every requirement in our code that they have met the substantial evidence, and the objectors have to show why he doesn't meet substantial evidence, theoretically. The applicant must show that they, by substantial evidence, can meet any condition of our code, and then they have to meet any condition that you might oppose that is reasonably related to the ordinance. Why do I say all of that? Because at the end of the hearing, and we're in the middle of 2 or 3 hearings in different communities in this county, you're going to say, as part of the hearing, conditions that you think might be reasonable that you might want to consider imposing. And then we have to adjourn so that the petitioner can prepare substantial evidence how they're going to meet or satisfy those conditions. And if there are any objectors to the conditional use, they get an opportunity to come back and hear what those conditions may be. So you can't just impose a condition at the last minute, because there won't be any substantial evidence that will stand up on appeal to show how they will meet or, agree to meet those conditions. So in Sussex, for instance, there's a 3-month process and maybe a 4-month process to get a conditional use now under the new law. The rest of it is procedural stuff, a Class 2 notice, a public hearing. Once granted, they remain in effect as long as they meet the conditions, unless you put a term limit on it. And if the city denies the conditional use, they have the right to appeal the circuit court. So then I want to go back to my letter just to highlight my December 27th letter, 2017, to highlight a few things, and then we'll leave a few minutes for questions of the Planning Commission and the board. So on the first page of my December 27th letter dealing with conditional use authority, new preemptions, 2017 Wisconsin Act 67, just talks about that this is a new law, the Landowner's Bill of Rights. It's in direct response. The legislators admitted why they wrote this law. One, that on the All Energy Corporation Trempealeau County case, the Land Use Committee denied the conditional use permit because of public pressure, in this legislator's opinion. You may have read this in the paper. It was written up when the town of Delafield was dealing with this issue. And he said he thought it was inappropriate. They met all of the conditions of the code, and they should have been given it. And it was just public pressure that stopped it from getting it. And so he was going to write a law to make sure that never happened again. And that's sort of what I'm telling you. The court upheld the denial based on the law as it was written at that time. And the legislators decided they were going to change that law, and so that in the future, that committee would not be able to turn down that, I think it was a mining request. So now we walk through the new preemption. Part 2 is pretty much what I've already went through. Talks about conditional use, substantial evidence, what the applicant has to demonstrate, how the conditions have to be reasonable, how you can limit the duration. You have to have a public hearing. You have to, it's a quasi-judicial decision, which is I'm going to highlight, and then the appeal. So our recommendations, you have to take testimony on the conditions. And so the planner now will be spending a great deal of time in his staff reports telling you what the requirements of the code are and what the conditions of the code are, okay? And that's what, and if you don't have your staff report for the conditional use tonight, you will want it, because he's laid out those requirements and he's laid out those conditions. And when people talked about the requirements or they talk about the conditions, that's when you got to really pay attention to deem whether substantial evidence is being presented as to whether those requirements and conditions are being satisfied or not being satisfied by the substantial evidence. And again, mere opinion, mere speculation. We respect everybody's citizen. We respect their opinions. But apparently the legislature has decided that that's not enough to constitute substantial evidence. Opinions no longer meet the definition under what the legislature had said. So we have to look at our codes to see whether or not they're going to conflict or not. I've already talked about the potentiality of special exceptions, whether site plan and plan of operations, public hearing notice. I think we've always been fine. And we're going to have to look at all our standard conditions. I'm on the bottom of page 5 to see whether we can still impose our standard conditions. I talked about if you're going to come up with specific conditions, they're going to have to relate directly to the code. We have to give notice of what those conditions are going to be, and we have to give the applicants as well as the residents, the neighbors, or any citizens or anyone appearing an opportunity to speak and present substantial evidence on any proposed condition. That's really important. What I want to end with is your quasi-judicial role on bottom of page 6. The governing body that participates in conditional use approvals, which is both the Planning Commission and the town board in this community, are judges, not legislators. That means they must be biased, they must be impartial, they cannot come to the hearing biased, or if they are, they must recuse themselves. You can have no ex-parte contact. Decision makers must avoid ex-parte contact, meaning they should not investigate the case or receive information about the case outside of the hearing and the public meetings. Now, that's a big change. And I have one community that one of the town supervisors, in all due respect, yelled at me. She said, my job as being elected is to talk to my residents and the citizens of this community. And I said, not when you're wearing your judge's hat. Unfortunately, if you were in a lawsuit, you wouldn't want the judge going out for coffee with one of the parties and hearing that side of the story outside of the hearing. And she had to acknowledge that that's true, that that wouldn't be proper for the judge to be out talking to people outside of the hearing. So you have to decide everything based on what you hear at the hearing, and you've got to not have ex-parte contact outside of the hearing. And if you have, you probably shouldn't hear the matter. You should probably step down on the matter. So with that, we have a few minutes for the board. If they have any questions, Mr. Chairman, I'll be happy to answer them. I think you're going to want to keep this yellow one real handy. The rest of them you may want to read at your leisure. We have a conditional use decision sheet that we'll be preparing when the hearing is closed, showing all of the requirements, all of the conditions, and then you're going to say whether the applicant provided evidence, whether the opponents provided evidence, and whether the Plan Commission finds though that they were substantially met or not.
Any questions from board or Plan Commission members for the council? Wow, you did a good job.
Take a break.
Sure. We're gonna take a break till 6:30.
7 minutes. Okay. Do you have any extra copies of the letter? Let me see. Right. I put that out. I got to keep mine for the hearing. Kathy, do we have an extra one of the letters? One more of the letter. I think we ran 11. I think my December letter she's looking for. Did I hand them down? Did they hand them out? I handed 7 of them down. I don't know if they all went down that way.
They got too much talent. Give them this presentation. It's something that they now
well, it's on the letter. If she gets you a copy of the letter, we sign the letter. We sent 7 down. I don't know if they were extras or not. She's looking. She's going to give you the engineers. Did I sign it? Let's just see if one of my partners signed it or I signed it. Yeah, I signed it.
I see the number, so just call you confirm there.
Sure.
All right. This is, this is.